Okay, welcome to everybody to this panel, and good morning to everybody. I don't know which time zone you are at, but in Europe it's Central Europe. It's 9 o'clock. So the title of this panel is Controversies: Issues in Customary International Law Interpretation by International Courts. And we continue to focus on customary international law. So it's interesting to discuss what is so special with customary international law as a legal source. And I think also, which we will discuss during the presentations or after the presentation, what is different from treaties when we deal with customary international law. We have three interesting papers. One concerns the possible conflicting customary international norms, how to deal with the conflicts between different customary international rules. The second is more empirical study about usually we discuss the effect or the condition of state practice to establish customary international law, and this paper deals with the opposite. How does customary international law decisions by courts influence the state practice? And the third is about customary international law and judicial activism. We know discussions about judicial activism concerning treaties. What about judicial activism when it comes to customary international law? And the focus is on international court. What is the role of international courts in these different respects? We follow the order of the program. Each speaker will have 20 minutes at most, and this will be strictly enforced by the chair. I will try to send you a chat when you have 5 minutes left, and then 3 minutes, so please check the chat. And then I think we take discussions after each presentation rather than collect it, because they are on different topics. So after each presentation, we will have 10 minutes discussion. So then we are ready to start with the first presentation. That's Raphael Oidtmann from the University of Mannheim. He will speak about reconciling conflicting norms of customary international law towards a mode of practical concordance at the ICJ. Raphael is a parliamentary and legal advisor at the Hessian State Parliament and adjunct lecturer at Mannheim Law School. He has a master's degree in political science, international and comparative law, and international relations. And presently, he's a PhD candidate at the Goethe University of Frankfurt. So please, Raphael, the floor is yours.
Thank you so very much for the kind introduction, and thank you for having me. As you said, the title of my paper, Reconciling Conflicting Norms of Customary International Law Towards a Mode of Practical Concordance at the ICJ. So this paper actually is supposed to be practically a thought experiment, first of all. The idea being that if we look at, well, recent and also not so recent international legal scholarship, what we see popping up more and more, I would suggest, is that there is the contingency of eventually conflicting norms of customary international law that we are facing throughout the field. So we have, as we all know, we have well-established norms of customary international law. They have a certain status, and the question seems to be, what do we do in case of, these norms substantively conflicting, or at least having the potential to conflict with one another. What we don't have, at least in my assessment, actually, is a let's say a set of instruments, a set of established instruments and rules of collision. What we have, for example, in many constitutional orders. And so the idea about having rather accepted and transparent rules of collision actually is that this might mitigate possible negative ramifications that could stem from a clash of adverse customary, in that sense, customary legal obligations. So the idea actually is to do something about this inherent tension of juxtaposed yet at the same time well-established norms of customary international law. And the most tangible example that I think of, or that I actually intend to look at more closely, is the notion of the material scope as well as the applicatory purport of personal immunities under international law. I think one of the examples where this tension becomes most clearly visible and most clearly traceable. So with a view to this example, so to speak, I was actually thinking of and this is also the part of the case study that is supposed to be featured in the paper. What do we do in case of a conflict, of a clash between, on one side, the well-established customary international law norm of immunities ratione personae, so personal immunities, particularly for heads of state and government. And on the other side, and this actually speaks to my background as someone who actually works in international criminal law quite a lot, with the also well-established principle under customary international law of ending impunity for international core crimes, with all the interrelated notions as to which crimes are included and so on and so forth. So the blueprint case of that, actually, the case where all of this becomes very very clear and quite traceable, is of course the almost endless saga in the case of Omar al-Bashir, former president of Sudan until he was ousted in 2019. As we, I guess, or most of us know, regarding the conflict in Darfur, there have been ongoing investigations and a situation before the International Criminal Court. There have been 2 arrest warrants being issued against Omar al-Bashir over the years, including for being responsible for having committed genocide in the Darfur region. And the saga actually also entails various episodes in which, and I'll try to cut that short because it's a very complex and quite shady story at times, I would say, including episodes where Bashir was traveling to countries that are also state parties to the Rome Statute of the International Criminal Court, and the question always was, well, whether or not there is a duty on behalf of these states to arrest and surrender him to the court. And then on various occasions, some of these states actually argued that, well, he is entitled to personal immunities under customary international law, and were therefore actually establishing a certain hierarchy, not only between possibly conflicting norms of customary international law, but also between, in that sense, customary and statutory regulations. So the al-Bashir saga actually is supposed to function as the example, actually to tackle some of the questions I was already raising en passant. So what do we know and how do we go about the fact that there might be norms of customary international law that are like in direct clash with one another, that are opposite to one another? What, if any, collision rules do we actually have, and how do we actually reconcile and mitigate consequences stemming from such a possible conflict and clash of conflicting norms? Also, of course, who is called upon to decide on this somewhat delicate interplay? Who is actually able and entitled and responsible for making a call on that? And of course, I guess our first move or first turn would be towards the International Court of Justice, since we are not only speaking about single issues and single criminal cases, for example. But of course, this goes to very fundamental notions of international law more generally. And so therefore, you could actually think of the ICJ being called upon to actually say something, do something about that. And so this is actually where the idea or where the notion of practical concordance is something that I thought was, well mooting, at least. Those of you who were somewhat familiar with German constitutional law, I'm pretty sure have heard about the principle before. In all honesty, it's not rocket science. It's a pretty straightforward approach, and it's not even it's not a legal principle. It's not even a legal theory, I'd say. I think it's more some form of of legal guidance. This is how I would actually perceive it. So practical concordance, therefore, actually resembles the attempt to reconcile prima facie conflicting norms, originally, as I said, in constitutional law matters. But I would actually wait and attempt to think about whether or not this could also be applicable with a view to the realm of customary international law. Perfect. Could you just go to slide number 4? Perfect. Thank you very much. Great. And sorry again for the inconvenience. So, as I said, it's stemming from German constitutional law theory, this idea. And in fact, practical concordance denotes not very much more than to say that you try to apply or actually create a legal equilibrium in such cases where, and again speaking from or coming from the constitutional angle, in which constitutional norms of equal rank coexist with one another, so they are on the same on the same level, they have the same status, there is no hierarchy between them, but you now have to actually find a solution to actually, to have them have a stand vis-a-vis one another. At the same time, the idea is that no norm should take precedence over the other. So what you try is not to actually, bring them into conflict, but to make sure that both are remain valid and exist on the same level, so to speak. And so the idea behind that actually is to strike a balance between those, equally strong, equally or norms of equal standing, and you try to reconcile them as gently as possible while allowing each principle to flourish to the greatest extent possible. This is just me trying to, or has been me trying to translate the German original here. And so the idea really is to say that it's not about one rule supersedes the other. It's about finding a way to actually mitigate between the two. Could you open the next slide, please? Just on to the end, if possible. Yeah, thank you. So in brief, this is actually actually again my translation from the pertinent German definition stipulated by Konrad Hesse. In brief, it's about constitutionally protected legal interests that shall be assigned to one another in solving a problem in such a way that each of them becomes reality. Limits must thus be established for both legal interests so that each may realize optimal effectiveness. In other words, in simpler words, probably either legal interest in question, either legal norm in question, and therefore also either a customary international legal norm in question, should thus not be realized at the expense of the other. So in the sense of, unduly or hastily weighing them against one another, and weighing conflicting legal interests against one another. So in that sense, actually, also according to Hesse, the principle of constitutional unity, and again, here we come from the constitutional angle, it's about constitutional unity, it's about coherence, and it's about impartiality. And I think these are, when I read these, actually, this is what made me think of, how can we actually make use of that also for the purposes of customary international law, because it should be, the over interest in my understanding at least should be that there is a certain, international legal unity, so to speak, that there should be some form of coherence, particularly when it comes to the application of international legal norms, both customary or statutory in nature, and that it's about to, in the end of the day, establish a balance between different legal positions, and in order to make sure that they have been reconciled in the most effective way. The next slide, please. And so the idea really is in the paper, as I also mentioned in the first tentative, very early draft, is still in the process of actually finding a way towards that. So the question for me would really be to say, or two things probably would be at the core. First of all, the practical concordance, as I said before, I mean, it's not rocket science. It's not a legal theory or anything like. It's guidance, but it's a guidance that is actually supposed to have those that, in the end of the day, are the ones to make decisions about how to reconcile possibly conflicting norms of customary international law, namely international judges, for example, at the ICJ, or most importantly at the ICJ. And so the paper actually wants to, on one hand, exemplify how this might be achieved. And in that case, I actually want to look more closely at what the appeals chamber of the International Criminal Court has done in the context of this al-Bashir saga, actually trying to do exactly that, to come to some form of balancing, and then actually try to extrapolate that to a certain degree, and to see whether or not this might entail helpful advice or useful guidance also for the ICJ. And if you look at the caseload of the ICJ, I would actually argue that even there in the past, there have been examples of actually of practical concordance in practice, without necessarily, I mean, not naming it such, but also not necessarily regarding it as such. If I think of the arrest warrant case, I think 2004, if I'm not mistaken, Belgium versus the Congo, where it was about exactly the question of personal immunities in that particular case of the foreign minister of the Congo, the Democratic Republic of Congo. The court was actually, entering this sort of like, this weighing process of establishing some form of equilibrium between, on one side, personal immunities, and on the other side, the need to actually end impunity for international crimes by making sure that alleged perpetrators can be held into account. And what the court in that case actually did, and I think this is what the notion of practical concordance is about in the end, is to look at the specific case, at the specifics of this specific case, so to speak, and then come up with a proposition or a solution as to how you can strike a balance between both perspectives. And what the court did actually was to say that, yeah, well, of course, heads of states, heads of government, foreign ministers, because of the fact that they hold personal immunities, they should not be prosecuted in domestic jurisdictions, but it's possible, at least with regards to international crimes, the core international crimes of genocide, crimes against humanity, war crimes, to actually hold them responsible in form of a kind of international or even future international criminal tribunal. And so this was a way of actually finding, common ground between two prima facie opposing or conflicting principles. And this is actually the idea that I want to develop further in the paper, actually to sort of like delineate actually an intellectual framework for, so to speak, right, for judges to actually just make themselves aware of the fact that in single cases, in unique cases where you have conflicting norms of customary international law, possibly conflicting norms of customary international law, it's also about judicial creativity in terms of finding a middle ground between those two positions, because the idea should be to say and should be to strive for a balance between the two and not to trump one in favor of the other. And so this is actually, as I said, these are tentative thoughts. This is very early work in progress. So therefore, this is where I'm very happy for your critique, for your feedback, and for your comments, which I very, very happily receive. And otherwise, with the last slides, just thank you very much for your attention. Sorry for the technical hassle at the beginning. And I look very much forward to your questions and to the remainder of the conference. Thank you.
Thanks very much, Raphael. Very interesting presentation. And as you said, yeah, you started with saying that this is a thought experiment, and I think that is also how we should approach it, with an open discussion of different ways to approach this issue about possible conflicting customary international law norms. So one can discuss whether this particular conflict between immunity and prosecution of international crimes is the best example. It seems to me that it's interesting to discuss. Of course, one could think of other possible examples, but this is, I think, an interesting place to start. So my approach then would be to elaborate or examine to what extent we can use what we know from collisions between treaty obligations on the one hand, and whether it makes a difference that we are now talking about customary international law and possible conflicts between them. Because when it comes to collisions between treaties, we have some established principles, and one can discuss whether they are applicable also when it comes to customary international law obligations and their collisions. So my question, or one question, would be, in terms of customary international law, wouldn't you rather go to the examples where states have faced this conflict between, on the one hand, prosecution and the other hand, immunity, and see what states have done when they have faced such conflicts, rather than examining prosecution generally and personal immunity on the other hand generally. So we are interested in this tension between the two, and then I would think that the number of cases should be selected to issues where states have faced this conflict. And then again, practice and opinion juris. So that's one question. Another question is this interesting thought about equilibrium, whether you can use that as a guiding tool to resolve such possible conflicts. As you say, it has been used in German law when it comes to human rights. So it is a question both of whether it's applicable beyond German law, and it's a question whether it's applicable beyond conflict between human rights. It strikes me you refer to Hesse. My association would be Alexei and his thoughts about this possible way of approaching it. But another aspect is that isn't this more a question of interpretation, how to interpret so that there is no conflict, to try to establish a harmony through interpretation rather than conflict between norms. And finally, we have the question about who decides, as you said, possibly the ICJ, but it could also be a question about what is the particular role of the International Court as opposed to any other decision maker like states. So how should the courts go about it, possibly as opposed to other decision makers? So these are some comments. Would you like to respond before I give the floor to other comments?
Yeah, very happy to. I will be very brief. I mean, these are very, very helpful and very guiding comments. Actually, I would actually try to respond to I think your first 2 points regarding that it should be about sort of like, you know, state practice in terms of how and whether or not they actually reconcile both. I think I should have made this more clear actually. So this is actually what I try to examine by going through this al-Bashir case, because I mean here it's about, I mean, for example, what did Jordan do, what did South Africa do, so countries to which or where Bashir actually traveled, and where the question actually was, is there an obligation to arrest and surrender him, and actually also to look at their arguments to say that he's entitled to personal immunities under customary international law, and so therefore this is why we decided not to arrest or not to respond. So that actually to trace this argumentation. Yeah, so and the question regarding the equilibrium, whether or not it's applicable beyond German constitutional law and also beyond the notion of human rights, my gut feeling would be yes and no. So it's in the sense it's applicable beyond Germany because it has been actually, well, not accepted necessarily, but has been referenced in other jurisdictions, including Switzerland or France, for example. Beyond human rights, yeah, well, I mean, of course, you know, this could be a thought. My hunch would be that it's not necessarily about the substantive content, so to speak, of, you know, legal norms we're looking at. So whether it's human rights or any other realm of the law, but about the question as to whether, as you said in the beginning, as to whether we have some form of hierarchy between different norms. And in that sense, I mean, you're absolutely right. It makes a lot of sense to actually go back and consult with the rather established rules of collision, or, you know, general rules of interpretation that we have with regards to statutory international law. And so, yeah, I think these would be but will be very valuable additions. So, yeah, thank you.
Thank you. Any other comments or questions? I see one. André de Hoog, would you like to raise the question in person?
I'm not sure if he can unmute.
Okay, so I can read it out. What are the limits of this principle of practical concordance? In other words, what if an equilibrium cannot be brought about and one rule must be given precedence over another? Is there some kind of fallback option in those cases?
That's a very, very smart question. And thank you, Andre, for raising that. Yeah, I mean, I think there is no general fallback option, and I'm not sure. I think you're right in the sense that it's, I mean, of course, you know, this, again, you know, it's not only a thought experiment, but it's only meant to be like, you know, the guidance, particularly for judges in terms of, you know, where to go and where to strive and deliberations, and actually coming to a possible way of reconciling possibly opposing norms. I think it's not against the idea or the general understanding of practical concordance if the equilibrium is not like 50-50 in the end. So you're right. There might be situations where one norm has to be given a bit more preference, where it has to take a bit more precedence. But I think it's more about, like, you know, the guiding rationale behind practical concordance, that it's not a black and white. It's not a 100 or 0 approach in terms of saying that, well, this norm has to supersede, and so therefore the other one, or substantively, so to speak, just vanishes. So, I mean, of course, and I probably should have stressed that more. I mean, of course, it's always a case-by-case approach. It's always a unique situation in which you actually have to which is very context specific, and in which you have to look at all the different factors available, so to speak. And I would be hesitant to say that in such situations it's an either-or situation where you have to actually turn to the left or right without being able to make an effort to also accommodate the somewhat losing norm to at least substantively, again, to at least a certain degree. And I mean, this is like this idea of an equilibrium is actually meant to indicate that there should be like a constant process of actually balancing to the best extent possible. I mean, and the best extent possible, I think, is the crucial qualifier here. It's not necessarily meant to say that it has to be 50-50, and otherwise it's worthless. But just to make sure that both, so to speak, legal interests are equally taken into account and are accommodated for in a final determination.
Okay, we have time for one last comment. Panos?
Yes. Thank you very much, Raphael, for this very interesting presentation. 2 points. One question as to, because the way you described the idea of practical concordance, it seems to me that it kind of is more of an umbrella term, that it covers both interpretation plus conflict resolution. And there, do you see it, with respect to interpretation, do you see it as something different, broader than, for instance, the practice of, well, for treaties 31.3c, or more generally the principle of systemic integration, or essentially what the ILC characterized as harmonization through interpretation? Do you see your idea of practical concordance as something broader, or is it the same kind of thing? And the second one would be that with respect to customary international law, you might find interesting also the ILC's draft conclusion 3, where they kind of refer to this reference to the normative environment. In my view, the kind of mixed a little bit identification with interpretation, but that's a different issue. And I think this was also raised by the Dutch advisory committee on public international law as well. And also the fifth report, since you talked a lot about acta iure imperii iure gestionis, the fifth report of the ILC on immunities has, is filled with all these ideas about conflicting customary obligations and how to find a balancing kind of that.
Very good. I think you have to be short now, Raphael.
Yeah, I can be very short. Thank you. I noted these hints. I will definitely consult them. And regarding your first question, very briefly, I think it's an umbrella term to a certain degree, and also, and this is why I think it's still very early on, and whether it's still open to discuss whether or not the notion of practical concordance is of worth to public international law more generally, because it has to be reconfigured to fit the international legal landscape rather than a constitutional law landscape for which it originally has been developed. But I think just in that sense, I agree with you, Panos, in the sense of being an umbrella concept and an intellectual guidance in terms of how to go about conflicting cases, that you then actually try to make sure that you have it in the back of your mind, that you try to strive towards this, let's call it equilibrium, or balancing process or whatever. That this is, I think it's not broader than what you described. I think it's just like probably a different way of looking at that, and probably a bit more focused on or towards those that actually have to make these calls in the end, just to be sure for them to have that in the back of their heads when they actually fulfill their judicial duty, that this could be a useful intellectual guidance to make sure that, or to try to make sure that both positions are somewhat, or to some extent, are being reconciled.
Okay, I think we have to finish now. Thanks very much, Raphael. Very interesting paper, and also your comments afterwards. Then we move on to the next paper. That's Ezgi Yildiz and Umut Yüksel, and they present a paper on how inconsistent takes on custom shape state practice. Ezgi is a senior researcher at the Global Governance Center at the Graduate Institute in Geneva. And her book, Between Forbearance and Audacity, How the European Court Defined a Norm Against Torture, is coming soon with the Cambridge University Press. Umut is a postdoctoral researcher at the Global Governance Center at the Graduate Institute in Geneva. He has a PhD in international relations and political science. And he has been a visiting researcher at Stanford University. Please, Ezgi and Umut.
All right. Hi, everyone. I don't know if you can see our screen. We cannot.
Yes, it's fine.
Can see everything. Okay.
Wonderful.
Hello from Geneva. We'll be talking, two of us, two talking heads today.
Two talking heads.
You want to first thank you all for inviting us and this wonderful workshop. We are sad that we couldn't be there.
So we are very happy to be here today to talk about how judicial takes on customary law shape the preferences and policies of states. Much has been said about how state practice feeds into custom and how state practice can be scrutinized to judge whether a customary rule exists or whether such a rule is solidified or what the content of that rule is. For instance, international courts and tribunals are usually called upon to identify, interpret, and apply customary international law. And as they do so, they're often expected to verify whether there is general state practice coupled with opinio juris. As many have pointed out, though, the process by which courts get there are usually not very transparent, and their pronouncements may not always be consistent with someone else's reading of that same state practice. We will bracket this question of whether courts read the state practice correctly and instead look at what happens after. We want to see how court judgments relative to the customary nature of a rule affect the subsequent uptake and the diffusion of that rule in state practice. We felt that this was an understudied area, especially we felt that there was a lack of empirical studies looking at state practice and how it is shaped by different types of judicial input. And we also felt that this was an important topic to study because not only can courts have a direct effect on state practice, leading state practice to converge or diverge, it can also have a conditioning effect on future court decisions, which then play a great role in how the customary law or law in general shapes up to be.
Perfect, thank you. So this piece comes out of our broader project where I work with Umut, and this project is financed by the Swiss National Science Foundation. And some of you are already familiar with some aspects of this project. We've been presenting some pieces coming from this. But our main goal for that project was to better understand the role of international courts in world politics. And mostly from the international relations perspective, because there's a few assumptions about what courts do and their impacts. And we wanted to tackle some of these assumptions looking at the field of maritime law. And some of these assumptions are very entrenched and widely shared, and those are related to functions of courts, such as courts clarify a law by completing complete contracts, they fill in the gaps in the existing treaties. And one also is related to courts' effect. Basically, courts actually can provide focal points for states to coordinate their policies. The underlying assumption here is that courts help harmonization of state policies, and by doing so, they will avoid dispute and also help states resolve their disputes. So especially this assumption about courts helping disputes and providing focal points has varying degrees of forcefulness. Sometimes it's a starting assumption, sometimes a passing assumption, but oftentimes it's widely shared, but sometimes also weakly stated assumption. So the understanding is that some of court rulings may serve as focal points, but then the understanding is that courts will either have a positive effect by providing focal points or a neutral effect by failing to do so. But there's not a lot of investigation into their potential negative effect and their potential impact in making coordination actually more difficult rather than easy. So this is the part that we come in, and this is the part that we will come in, and we want to examine this in the context of how courts interpret custom. Because the statements about custom by definition are about the moments where courts can actually make a statement about the general international law, general principles in a generalizable way. So it's going beyond the case at hand. And in that regard, International Court of Justice in particular has a special place to make such kind of statements about what the law entails. And in a way, the statements are not just binding on the parties to a case, it's binding or it's influencing all parties concerned. That's why we think that International Court of Justice is likely to have a sizable effect here as the World Court, as the General Jurisdiction Court. And in particular, when it comes to pronouncements about customary international law, International Court of Justice is also given a special place by the International Law Commission's draft conclusion on identification of custom, which Panos mentioned previously. So we examine the ICJ's impact on state practices in the field of maritime delimitation. This field is particularly interesting because there are multilateral treaties governing this field, but their influence is somehow limited. This is because either existing treaties contain clear provisions, but they are not widely accepted by states, or they are widely accepted by states, but they do not contain clear provisions. So this means that there's a lot of room for courts and especially ICJ to play a role. So this field also is interesting for us because it's a good testing ground to assess the influence of courts that they might have on state policies, because in this field, we see that available legal rules and geography instead of ideology or power differentials are more important. The usual political default lines between North and South, East and West don't matter as much here. It's all about what rules benefit certain geographies. And in a way, if we want to understand the role of courts in an uncorrupted way, this is one of the best places to look at.
All right, let's see. So we thought that there would be a lot of different relevant factors that may condition the effect of court pronouncements on state practice. Here we focus on two dimensions. The first dimension is about the state of the practice at the time that court makes a judgment about the customary status of a specific rule. And here we consider the possibility that there is already a majority of states that follow the rule or have expressed a preference in line with that rule. Another possibility is that the majority is against that rule. And a third possibility is that there is no majority either way, or there is no substantial state practice yet. The second dimension is what the court does in its judgment, so the nature of the judgment of the court. The court may declare the rule to be customary. It may refuse to declare the rule to be customary without proposing something else instead. It may instead declare an alternative rule to be customary. There are also, of course, other aspects and other dimensions that we don't look at. We explore some of these in different projects, for example, distributional consequences associated with different rules. Based on these, we create a 2x2, and we focus on just the most extreme options in each of these dimensions. Our expectations can be summarized using the set table. So we basically expect that if the court declares a proposed rule to be customary, it can have an effect that it can have a convergent effect in the state practice if most of the states were already in favor of that rule. But it may fail to have such an effect if most of the states were against that rule. We also consider the possibility that the court declares an alternative rule to be customary. And in that case, we expect there to be actually divergence, even if there was sizable following in the original rule, because some of the states will change policies depending on whether the alternative rule is now more beneficial. But if most of the states were actually already against the rule that is proposed to be customary, there might be convergence around this alternative rule. Our empirical strategy consists in looking at state practices over a long period of time as courts make different judgments about the customary nature of different potential delimitation rules. So we have collected original data on state practices over their preferred rules of continental shelf delimitation methods. And we looked for these preferences in various areas. We looked through their domestic legislation. We looked at their unilateral declarations and statements before the courts. We also looked at their bilateral treaties, especially when these treaties suggested that there was a common understanding as to what the states thought to be the delimitation rule. Our dataset runs between 1960 and 2016 and records state preferences that we categorize into two potential outcomes. So they could prefer either equidistance or they could prefer what we call equity, which covers all the other methods that significantly deviate from equidistance. The equidistance principles basically means that the delimitation line should be drawn such that it's equally distant from each relevant cost. Equity does not really refer to a single main method. It's more of an outcome. And a delimitation exercise can have an equitable outcome through various methods that do not necessarily include equidistance.
So I will take over again. So arguably, we can, based on that, we can assume that equidistance had been the default rule and it had more or less a consolidated status because it was also codified under 1958 Geneva Convention on Continental Shelf. And that then came the ICJ with its North Sea Continental Shelf ruling in 1969, a ruling that most of you know. It's a very important ruling for international lawyers. But what we see here is that in the context of maritime delimitation, here we see that the court rejected the application of equidistance and pronounced that equidistance is not the method, it's not the custom, certainly. Instead, the court endorsed equitable principles and pronounced that custom would require the limitation exercise to be carried out in light of equitable principles, taking into account all the relative circumstances as well. So until 1993, ICJ was consistent about not giving equidistance any prominence in its rulings and endorsing equity in various ways. However, what we see, and we will see in a minute when we're showing you the graphs, that we don't see any significant convergence around equity either. Then in 1993, in Mannheim ruling, where while still insisting on the fact that custom or the claim that custom requires an equitable outcome, the court began to bring elements of equidistance and fuse it with equity. But we want to also now understand how these different approaches to equidistance in a way shaped state practices. And for that, we will go to the graphs now and our data. So here we see that the graph starts in 1960, right after the Continental Shelf Convention was signed in 58. The pattern in dark blue is for equity and the pattern in lighter blue is equidistance. And the lightest one is countries without any preferences. For the moment, we will ignore them because what we care about right now is the countries with an express preference. So what we here see is that before the 69 ruling, the majority of the countries in 1968, for example, 80% of the countries with an express preference, they were for equidistance. And equity supporters in that period, they were in minority. However, when we see the next slide, we see that things immediately changes after the 69 ruling. We see that this ruling endorsed equity and the ratio of states supporting equity quickly jumps after, and at one point it reaches 50% around here, before the Mannheim ruling. And this suggests that court's intervention had a strong effect in stopping the rise of equidistance and increasing the popularity of equity here. But when we look at the overall picture, we also don't see that any consolidation or any convergence around any of these methods, actually. It's a quite divided state practice. And this divide has to be, seems to be persistent from the 80s onwards. So what we see here is that this is a case of a court going against an emerging popular rule by endorsing an alternative. What we see here is on the lower hand corner. And this creates divergence because the court's endorsement of equity does not eradicate equidistance altogether, but instead gives states license to pick and choose between equity and equidistance. And having alternative rules equally legitimate creates opportunities for the states to contest and diverge.
All right, so in summary, we find that state practice significantly diverges as the court in 1969 refuses to declare equidistance customary, although it had supported a considerable, it had enjoyed considerable popularity. And as a result, we saw that there was a polarization of positions where 50% followed the original potential default rule, whereas the other 50% followed equity and more relatable, principles related to that. These positions had stickiness in state practice. They also kind of conditioned the future attempts of the courts to interpret the customary law of continental shelf, customary rule of continental shelf delimitation. Some takeaways. We find that the positions that courts take on a rule, especially a court like the ICJ, and especially about the question of whether a rule is customary or not, has wide-ranging consequences. But we also should mention that the influence of the pronouncement is not overwhelming. Practices whose customary status are denied do not necessarily disappear, presumably because they still serve the interests of at least some states. And conversely, alternative rules that are proposed as customary are not necessarily adopted overwhelmingly or overnight, presumably because alternatives do not make all the states or even the majority of the states better off. We suggest that future studies look at perhaps other judicial bodies and the effect of their pronouncements on custom, and perhaps also look at the impact of such pronouncements in other issue areas. We thank you very much, and we're looking forward to hearing your comments.
Thanks very much to both of you. I think this is very original in the sense of going the opposite direction, asking the impact of court decisions on state practice rather than vice versa. And it's also interesting as an expression of interdisciplinary approaches between law and empirical methods, political science. So I will give some comments first before I open the floor. I will structure first in terms of hypothesis / expectations, and then methodology, then results, and then alternative explanations. When it comes to hypothesis, or what you say, expectations, you say in the paper that this is a zero-sum game, in the sense that if one state gains, another loses. And then I would think that the expectation would be that for every state claiming equidistance, the opposite state or the adjacent state would claim equidistance. So one would assume that there is a 50-50 on the one hand equidistance, and on the other hand 50% equity. So I think that is interesting in itself, and which may be different from other legal issues where there is not necessarily a zero-sum game in the same sense. Then when it comes to methodology, this distinction between equidistance on the one hand and equity on the other hand. So equidistance is clear in the sense that you share equally, but equity is much more complex in the sense of to what extent you should rely on islands, whether they should be given half effect, whether you should take into account the proportionality and the length of the coast, etc. So then it might be a question whether states are really for equity, or they are for that islands should not count. A more specific point of view. And also where you would find these different expressions, you might find them in legislation and unilateral statements, whereas bilateral treaties would not usually say anything about the methodology, whether it's equidistance or equity. The treaty would say where the line should go, and not the method by which to establish that line. When it comes to results, it seems to me that you are somewhat inconsistent in your paper, that you seem to say someplace that it has a significant, the court decisions have a significant impact, but it seems to conclude that it has some impact. So I'm not completely sure about what impact. And then fourth, discussing causality or alternative explanations. Could it be also that as one possible alternative explanation that states are learning over time, they see that this is important for them. They try to find out what are the consequences of equidistance, what are the consequences of equity, and that would also contribute to forming their views of what is in their interest. And then finally, now the ICJ, and I think also ITCLOS has a three steps approach, usually starting with the equidistance, asking whether there are relevant circumstances to change the equidistance, and then a final step about the overall equity. And whether that makes a difference for the future, or could we expect any difference? And then it would be interesting whether, if you take the full circle, if you say that ICJ influences state practice, and whether then this influence in state practice then feeds back to the ICJ, so we have a full circle, but that is perhaps going beyond what you will do. So these are some comments, and I would like to hear your responses.
Thank you very much. These are very good points. Well, to maybe go in order. Yeah, I really like to comment about how perhaps the polarization that we see in the end is consistent with the zero-sum structure of the issue. I think this is something we can definitely mention in the paper. Maybe given what the delimitation exercise involves, it's not really surprising that there is this 50-50 division. And we agree that equity is much more complex, and we struggled a bit as we try to categorize different kind of methods within equity, and we also are aware that states can have different they can prefer different shades of equity. Maybe they are completely happy with equidistance, as you said, but they are just not happy with islands getting full effects or things of that sort. And we could look into state preferences or express state policies in a more nuanced way to see what their beef with equidistance is, and that could perhaps be a more nuanced account.
I can take over, and
you can take over.
Okay. Thank you so much for the comments. They're very thoughtful, and it's going to make us think about this paper and structure it even better. So I will take the one about inconsistency in our take, and I think you're definitely on point, because we are kind of oscillating between talking about the court's overall impact in shaping state practice versus court's impact in coordinating. I think we have to make a distinction between that. What we see here is that court definitely has an impact in creating a following, but it's not necessarily for coordination. So that's why we need to take this maybe and explain it in two parts separately. When it comes to alternative explanation, that's absolutely right. And this is something we can also qualitatively explain as well. Some of the countries that are for equity, such as Germany or Turkey, for example, Germany, they signed on to the Geneva Convention knowing that it's going to have equidistance as a default method. They did not have a reservation about it, but they didn't ratify the treaty. Later on, they said, this is actually not working for us. We don't want this method. So in a way, since continental shelf delimitation is such an invention at that time, they didn't really have a full understanding of how equidistance is going to bind them and constrain them in a variety of ways. So in a way, there was a learning moment as well. And the confusion is also a little bit about that. An initial uptake of equidistance could be about the fact that nobody really understood what equidistance could mean, because it would make the field very technical. It would make the field such a technical thing that you wouldn't need to do a lot of negotiations unless you don't have this complicated island situations, for example. Finally, maybe about the three-stage approach. We don't have that in this paper, but we do consider the three-stage approach a stage approach, and we call it modified equidistance, relying on previous work in this. And what we see actually, it is the one that has the least following, weirdly enough. So because of all the confusion created by these two alternative approaches, it's difficult for a court to consolidate anyone under this three-stage stage approach. That's something that we have in another paper, but we can refer back to this one as well.
And yeah, maybe it needs some time to actually show its effects as well.
There is also that, because it's 2009, very recent. Yeah.
Thank you very much again.
Thank you. I have one question in the chat, and then I see that Soterios Lekos has raised his hand. I take the question in the chat first. It's from Nina Mileva. Thank you, Ezgi and Umut, for this interesting presentation. I want to ask whether in your research you also had a chance to see how domestic courts in particular are affected by pronouncements of the ICJ with respect to custom.
So thank you very much. We didn't look at domestic courts, but we are aware that some constitutional courts in some countries have, I guess, have annulled, I guess, the limitation treaty signed by the executive. We haven't looked into on what basis they did so, but we can. One guess is that maybe they thought that it was unconstitutional because the state did not take advantage of the state of the international law, which said that equitable outcome had to be reached, and maybe they did equidistance. Maybe the treaty between Albania and Greece, which was never which was subject to a constitutional court ruling, that could be something that we could look more closely into.
Okay.
But
Yeah, very good. And finally, now Soterios Lekos, did you want to take the floor?
Thanks a lot. Thanks a lot for your presentation. Just I would like to seek some small clarification. The first one is, from what I understand, you are taking up the distinction between territorial sea and continental shelf, or not? So perhaps this should be clarified, because the rule for territorial sea is equidistance. And the second is the issue of concurrent causes, which the chair also raised, Professor Ulfstein also raised. So, for example, there is during the period you examine, of course, there is 9 years of the third conference on the law of the sea, which is an intermittent cause, perhaps. And of course, the 2008 Black Sea, which a decision which we all discuss, the 3 steps approach is the 2008. So perhaps, is this something that you take into account in caching the data or not? Thanks a lot again.
Thank you very much. On the first question, you're right that we should be more clear. We are focusing on the delimitation rule regarding the continental shelf and not the territorial sea. And the data is also about continental shelf, and all our conclusions apply only state preferences as to the delimitation of the continental shelf. On the second question, so we tried taking into account UNCLOS and other types of legal input, or maybe input from negotiations in different ways. We try to detect change points just looking at the time series that we had to see after which years or after which couple of years there were significant changes in the popularity of certain rules. We didn't really find any significant changes in preferences around the time of UNCLOS. I think it's too early to detect change points around the most recent ruling that established the three-stage methodology. But that is something we can check in the future. Narratively, we try to address some of these issues, but of course, it's hard to identify an exogenous effect to just one decision, as the decision leads to perhaps some confusion in state practice, which then feeds into some of the debates of UNCLOS, which then kind of sustains the polarization that we identify.
But nonetheless, there's an interesting dynamic between treaties and courts here. What we see is that 58 convention was such a clear convention about continental shelf delimitation, and then the court came and made it a bit unclear with the 69 decision. But what we see also during the conference of the UNCLOS, for when also the resulting treaty, it ended up in a very unclear provision about it. It's not having a very clear delimitation method. And then courts now steps in and tries to clarify this. And 2009 decision, Black's decision, is coming with that effort of courts trying to correcting the under definition that we have in the 82 convention, I would say. So in a way, there is an interesting dynamic here, which we could also add in our narrative as well.
Yeah, definitely.
Okay, I think we have to stop there. Thanks a lot, Ezgi and Umut. We go on to the next paper, Leoni Ayoub. She will speak about judicial effectiveness or judicial ambiguity is customary international law and instrument for judicial activism in excess. And Leoni obtained her PhD in earlier this year. On the thesis called Judicial Activism and Restraint in the Creation of the International Judicial Function. How have activism and restraint shaped the International Court? She is an LM in Public International Law from the University of Kent in Brussels, and also an LM in European Law from the Université Libre de Bruxelles. So please, Leoni, floor is yours.
Good morning. Thank you, Professor Ulfstein, for the introduction. I'd also like to thank the Tricky Law team for the opportunity to speak today. It's certainly an honor to be here. So the question that I'll be addressing is judicial effectiveness or judicial ambiguity. Is custom an instrument for judicial activism in excess? So the question aims to examine the extent to which custom actually allows for the courts to exercise judicial activism during its determination, and whether this leads to an effectiveness of the judicial function itself. Custom therefore becomes a tool by which we measure the effectiveness and its utility as custom within the judicial process itself becomes important. And as the question may indicate, there are numerous levels of the analysis that will take place, and this will actually be a more practical exercise rather than a theoretical one. Firstly, we'll have to examine what judicial effectiveness and ambiguity actually are. We will then have to define judicial activism for the present purposes before proceeding to look at the actual case law of the international courts and consider whether activism has been a tool for judicial effectiveness. I will preface my discussion by noting that my research is by no means focused on customary international law. My background is primarily on the judicial function and judicial interpretation in general, and the effects of activism upon them. So I do hope I will successfully bridge the gap between the two within the limited time that I have in the presentation today. I'll therefore begin with some clarifications. Firstly, the term of judicial effectiveness. With many different practitioners and many different academics writing in this field, there are a number of definitions that one can take. But the most common understanding of the term holds that judges must render decisions that are unambiguous, applicable, and effective at resolving the dispute between the parties. By contrast, judicial ambiguity would imply that the decision cannot be effectively enforced, does not resolve the dispute at hand, and/or that the decision may include ambiguous legal reasoning. And while judicial effectiveness can be measured in numerous ways, depending on the legal system in question, and also by reference to the eye of the beholder, there are three components to consider when looking at effectiveness. Firstly, whether the decision serves a public and a private function. In other words, beyond resolving the dispute between the parties, does the decision also attempt to positively create norms and laws beyond the case that will generate obedience? Secondly, does this lead to a systemic harmonization of international law, making it a unified legal system despite the fragmented nature that we all know about? This measurement considers the principles that are laid out in judicial decisions must contribute to the emergence of common standards that apply to the international community at large and across judicial institutions. It's the sort of judicial dialogue that was referred to yesterday by my fellow panelists. Finally, there is the third measurement, which is reluctant lawmakers, a term that also has multiple meanings, but for the present purposes, I will focus on the idea that, well, it does not aim to go beyond the idea that judges are meant to simply identify and apply the law, the very traditional understanding of the judicial function. Instead, reluctant lawmakers implies that in identifying and applying the law, by the very nature of the judicial process itself, they're also creating it. In other words, the act of judicial reasoning, judicial lawmaking ipso facto exists in some shape or other, usually under the guise of judicial interpretation. And in recognizing and applying the law, judges declare what is and what isn't the law. However, you'll notice that my question also had another component, which is also very unclear and highly debatable, which is judicial activism, and by extension, the contrasting judicial restraint. I will say that there is no clear definition about what activism and restraint are. Various authors have accorded such a massive multiplicity of meanings that one cannot even delve into within the confines of a PhD thesis, let alone within the confines of this presentation. One universal observation, however, is that in examining activism and restraint of the international courts, we also examine the boundaries within which the judiciary functions. That said, and inspired by the former European Court of Human Rights Judge Mahoney, the analysis will proceed on the basis that activism and restraint reflect two sides of the same coin. They form one characteristic of the judicial function, and it's not a separate, they're not a separate act by the judge. Instead, they sort of describe the process by which a judge makes sense of a new rule or a new law. Furthermore, neither provides for a negative or a positive connotation. They're complementary. They work simultaneously through the judicial reasoning and manifest themselves within judicial reasoning itself. That said, some criteria by which we can identify activism or restraint can be deciding against the will of the parties or state consent, changing the judicial process in flagrant opposition to rules or regulations, modifying the law from what it was or what it was previously stated to be, deriving legal reasoning from abstract ideas without any clear certainty as to what their true definition may be. Result-oriented judging actually is an indication of both activism and restraint, depending on what the final result is. And finally, the unwillingness to interpret or provide an explanation of the reasoning is undoubtedly judicial restraint. As the very essence of the conference and our discussions these 2 days holds, we can see that methodology to identify and apply customary principles is actually highly contested. But one common thread is that the determination of customary law is itself a process of thought. It leads to a judicial pronouncement at the end. It's in a dialogue, so to speak, that is carried out by the interpreter in order to reach some conclusion of what is and what isn't the law. And that is why it is so fascinating from the activism and restraint perspective, because the process of identifying custom can also be reflected in the process of identifying activism or restraint, and making use of either tool quite fascinating by the judiciary. Quite central to my analysis, however, is also the very contrasting idea on methodology that was also mentioned yesterday, which is the idea that has been introduced by Stefan Thalmann, which characterizes the assertion of the law, in particular by the ICJ, and he describes it as the court pulling a rabbit out of its hat. How can customary international law reflect a lack of effectiveness of the judiciary? To do this, I have chosen the monetary gold principle, also known as the Indispensable Parties principle, that was introduced by the ICJ in the case of the same name, where the court held that it will not exercise its jurisdiction where the legal interests of a third state would not only be affected by a decision, but would also form the very subject matter of the decision itself. This was apparently well established within and embodied within the court's statute. I will add that I'm the one who added the emphasis to the text on the screen. Turning to the methodology of the reasoning of the court, however, we are faced with a few difficulties. This was a 19-page decision, which is arguably a short decision by the ICJ. It dedicated one paragraph to presenting the principle as embodied in the statute, without indicating as much as what embodied means or where in the statute it found this. And in another paragraph, a few further down the page, it highlighted its reasoning that it would not adjudicate because of the third state's interests forming the very subject matter of the decision. In turning to the criteria that I presented earlier, we can identify a rather short and very result-oriented decision. It did not want to adjudicate. We also see the introduction of a new principle, irrespective of the fact that it claimed it was well established. We don't know what the true source of the principle is. Finally, we also arguably see that the court decides in contrast to the very principle of state consent. It actually accorded priority to the lack of consent of the third party over the actual consent of the parties before it. Which seems to be quite a contrasting notion of applying state consent. So activism, in fact, seems to be quite prominent in the decision of the court. This proclamation, however, raises some questions. Can the clarity of the very methodology by which the court reached its decision reflect an abuse of activism and promote judicial ambiguity? Arguably, the court did try to promote a public function of protecting absent states from being embroiled in proceedings that they did not accede to. But we do see an assertion, nevertheless, that imaginary rabbit being pulled out of that imaginary hat. And the recognition of the principle continued within subsequent case law of the ICJ. In the case of Nicaragua, it did actually go on to engage in a greater analysis of what the monetary gold principle may be, but it expressly held that it was itself the limit of the power of the court. in certain phosphate lands in Nauru, it attempted to clarify once again what the monetary gold principle was when it said that it should only reject jurisdiction when the decision would affect the legal situation of the party, finding that on the facts of this particular case, it didn't. So we saw a sort of a focus on the degree of possible implication of the legal interests of the third party, while the court actually avoided using the very wording of subject matter of the decision. But then we come to the case of East Timor, the only other case the ICJ has applied this principle. Here, the court noted that it could not render a decision without ruling as a prerequisite on the rights of an absent third state. In other words, it brought in a temporal precondition to the application of the monetary gold principle. So the party's legal interests can only be decided upon after the determination of that third state. Again, I am the one who added the emphasis on the screen. Most notable is, in this actual case, however, is the fact that the court avoided answering questions of erga omnes and self-determination of non-self-governing territories. And in accordance to the criteria, we can actually see this, a sort of we can see a clear indication of restraint, actually, because it was a decision not to decide on certain particular important principles. What is even more notable is the fact that the way that it applied the monetary gold principle seems to create even greater ambiguity. Firstly, we see this introduction of a new temporal precondition, which did not appear beforehand. It actually references the Nauru case, but rejects it. Furthermore, and most importantly, even the monetary gold principle seems to have been misapplied. If we go back to the decision of the monetary gold, we actually saw that it was the subject matter that must have been the context of the legal interests of the states at hand, not the legal process. By bringing in this temporal precondition, the court arguably alludes to an issue of process rather than final decision. And it's a sort of possibly a jurisdiction versus admissibility argument that lies beyond the confines of this particular analysis. So was East Timor judicial activism and restraint? Arguably, it decided in a manner that caused even further confusion as to what the monetary gold principle was. It changed the most recent interpretation by looking at the degree of implication of Nauru, and it also decided to avoid answering or providing an interpretation for questions of erga omnes and self-determination of peoples. So we can't deny a sort of restraint on the part of the court, while it was a very result-oriented decision to not decide on certain principles. Beyond the ICJ, the principle of indispensable parties has also seems to have maladjusted in international law. Admittedly, there is one decision that applied the principle, and this was Larsen and Hawaiian Kingdom by the Permanent Court of Arbitration. The arbitral tribunal decided to go ahead and under the circumstances, it decided that it was applicable, but it's actually quite questionable the extent to which this can be used as any sort of precedent, if possible, because there seems to have been a motivation by the parties to raise publicity for the nationalist causes rather than dissolve an actual dispute, so it had to find a way to get out of that case. The more recent arbitral tribunal of South China Sea arbitration was also called to decide on the indispensable parties principle, but it held it inapplicable, as did the ITLOS when it recognized the principle in North Star, but held it inapplicable under those particular circumstances. Another case that actually brought the principle into its the principle came into its purview was the Western Saharan campaign and UK case mentioned yesterday, under the opinion of the Advocate General, who held that the concept could not be applied in EU law because it would automatically exclude the examination of agreements with third states. Similarly, 2 decades earlier, actually, a panel by the WTO held that the concept of essential parties was not applicable in WTO law. And finally, and very recently, the International Criminal Court rejected this principle by holding that the jurisdiction of the court does not concern interstate disputes, but deals with natural persons instead. And an even greater contrast is the monetary gold before the European Court of Human Rights. In the case of Bankovic, the principle was raised by one of the parties, but the court rejected the jurisdiction on other unrelated grounds. However, if we do consider extradition cases, such as Söring or Mamat Kulov, we actually see the court explicitly taking into consideration the conduct of states not party to the proceedings before it, but not even party to the convention. So we may arguably identify a practice that is explicitly contradicting the monetary gold principle. So coming back to our 3 measurements of judicial effectiveness, on the public function of the court has been trying to fulfill. Arguably, it's the very reason the monetary gold principle was introduced in that case. However, we must also consider the utility of leaving disputes unaddressed, which was the case of East Timor. The egg omnis and self-determination were both principles that the court could have easily and perfectly been suited to legislate upon or decide upon. Apologies for the wrong use of the word. Secondly, on systemic harmonization, if anything, we can see a disharmonization amongst the international courts. Finally, on the case of reluctant lawmakers, in fact, this is where the question of methodology in custom actually becomes rather important. Does an occasional recognition of a rule make law? We saw the court itself rarely applying the principle. We saw other judicial institutions, in fact, rejecting it. The answer with regards to reluctant lawmaking seems to be quite negative in that regard. Finally, coming back to the question of customary international law as a tool for judicial activism in excess, with the lack of certainty, both as regards to the source and the application of the principle, the principle of indispensable parties appears to have been the sort of rabbit being pulled out of the judge's hat through the use of judicial activism. And this alludes to the principle being used in order to avoid certain questions, possibly even political questions. But this is, of course, but a speculative exercise on my end. But it does certainly allude to a component of judicial ambiguity more than effectiveness. So, in conclusion, while there is a clear answer cannot actually be given, we certainly see the use of assertions and rabbits and hats, often under the cunning use of customary international law, alluding to the use of custom as a tool by which activism can manifest in excess. Thank you very much.
Thanks very much to you, Leoni. Very interesting, and of course, rabbits and hats are also very interesting. So again, I think we have the issue of we know what we mean about activism when it comes to interpretation of treaties. We feel that there is some activism if the interpretation goes far beyond the text and is furthering the objectives, object and purpose of the treaty, may be seen as activism. And but what about activism when it comes to customary international law? What should be characterized as activism? Is it to stretch the state practice and opinio juris? So what is exactly what we mean by activism? And we don't necessarily have an object and purpose of customary of state practice as we find in interpretation of treaties. So how do we use activism when it comes to customary international law? And then we have the question about which you raise also in the title of the paper, the relationship between activism, effectiveness, and ambiguity. Is there a clear relationship between activism on the one hand, that it would lead to either more effectiveness or more ambiguity? Activism could be seen as necessary to have rules that are relevant for the needs of current society, which could then lead to more effectiveness. I think to explore further the relationship between activism, effectiveness, and ambiguity would be interesting. And then we have the question with your particular case, Monterey Gold, and whether that is an issue of customary international law or not. Is it a matter of interpreting the statute? Is it implied in the statute? Is it some inherent powers? Is it or is it customary international law? And what is the relationship between these different bases for a rule? And also usually I think we will discuss customary international law concerning substantive obligations, but this is about procedural aspects. So what is the function of customary international law when it comes to the procedural aspect of ICJ's jurisdiction? Should we speak about customary international law in such issues? And then you discuss rightly the different subsequent cases. The first issue would be whether Monterey Gold in itself was an activist judgment, but then the subsequent would be what are the effects on subsequent judgments, and could they also be seen as activist or restraining or whatever. So these are some observations, and I would invite your responses.
Thank you very much for these insightful observations. And most of them are questions that are consistently running through at least my mind when I'm examining the relationship between activism and custom, but also activism and judicial effectiveness, which is a more direct liaison for me, at least. With regards to custom and its relation to activism and versus its activism and its relation to treaties, arguably, if we are to look at custom in a more positivist light, and therefore accord it a sort of a tacit acceptance of custom as law, there technically shouldn't be an issue in its examination. But issues do arise when it's not clear whether a principle is custom at all, how it ended up being custom, whether it was induction or deduction that brought us to this conclusion. So it would certainly be a matter of a case-by-case basis examination. Going on to whether monetary gold principle is itself a custom. This is actually quite a fascinating question in itself. It can be viewed as a matter of inherent jurisdiction of the court. It can be arguably viewed as a general principle of law, of international law, that it just seems to apply. It could be just a sort of guiding light for the international courts to use whenever they need. However, the fact that we cannot actually specify what it is exactly is firstly what makes it so fascinating in this particular instance, but also the sheer fact that we can see it being brought up within different international fora as well, sort of creates this sort of acceptance by states. Of course, one would have to look into the very reasons the states decided to bring it forward. Was it because it was a last resort and trying to get out of a particular case? There are numerous speculative reasons that we can have a look at it, but it is accepted. One of its characterizations is customary international law, and that's what led me to bring this analysis forward.
I think we should, because of the time, ask whether there are any other comments and questions, either by raised hands or by email. Panos.
I'm trying to turn on my camera, but yes, I think I managed to do it. So Leoni, thank you very much for the very interesting presentation. I think my question kind of ties to some of the observations that Geir already mentioned. But basically, wouldn't essentially any kind of determination of whether something is judicial activism versus restraint be dependent on a certain preconception that you might have as to the existence or not of a customary rule of a particular content? So that will be my question to that.
I think we also add André de Hog before we give the floor to Leoni. André?
Yes, thank you for giving me the floor. I'm a little bit puzzled by the idea that with the monetary gold case, the ICJ kind of pulled a rabbit out of the hat. If only because the idea of the monetary gold case was actually already applied in the Eastern Karelia advisory opinion of the Permanent Court of International Justice. I believe it was also applied in a decision of the Inter-American Court of Justice at the beginning of the 1900s. So the idea of it was already around, I would say. A second point I would make is, well, you know, you can argue all kinds of ways about judicial activism, and you seem to be saying that in the East Timor case, that was an issue because the court could have used the erga omnes character of either the obligations of regarding self-determination or the erga omnes character of the right of self-determination. But the whole idea of erga omnes was precisely the result of judicial activism to a certain extent. So I don't quite see how trying to characterize something as judicial activism or a judicial restraint per se helps us in the analysis of the legal issues concerned.
Before I give the word to Leoni now, a question to the organizer, Panos, Marina. We have, it's now 10:41, and we have a breakout session that should have started at 10:30. So how do you go about now? Sorry for not keeping the time.
No. I mean, let the one without sin cast the first stone, and definitely I'm not without sin on this one. I would suggest that that's okay with Freya, who's chairing the next panel, and the speakers, that we give Leoni the opportunity to respond. Then we have a break and we start at 11 o'clock. We had planned, you know, of a kind of a discussion towards the end, but you know, depending on how many people there are, it won't have to go that long. So I think we can be a bit flexible.
That's fine with me as well, by the way.
Okay.
And I know
Thanks,
that in the chat there is a link to the breakout
yes,
room.
during the break. Yeah.
Yeah, so now we give I give the word to Leoni as to a final comment, and then we have the break, and we start at 11 o'clock afterwards. So Leoni.
Thank you very much for these very fascinating questions. I'll try to be brief. As regards the determination of activism and restraint being dependent on the existence of a customary rule of particular content, I would argue that this is not necessary because of obviously the analysis that I've carried out here is very brief and did not go into detail on the criteria of activism and restraint and where they come from and how they attach themselves to the very judicial function and the role that the judges seek to actually fulfill in applying their judicial reasoning. So I would actually argue that judicial activism and restraint, through the criteria that I have brought forward, would allow, and as is also seen in Monetary Gold, we don't know the exact source of the case of the principle itself, and yet we were able to apply activism or restraint and to figure out what the judge was actually was speculatively doing, because we don't know what happened behind closed doors in the decision making itself. And this leads me to the analysis of the legal issues concerned and how judicial activism and restraint affect and provide any substance to those legal issues. The fact that my research was actually mostly concerning the judicial function and the effectiveness of the function and how that function came to be created through the procedural, the very procedural principles that the international courts have been building over a number of years. This ties well in that area rather than the actual substantive law of ergamnus or the self-determination of non-self-governing territories. So as was mentioned by Professor Ulfstein earlier, this attachment of activism and restraint upon the procedural aspects rather than substantive law is actually more important in this particular case. With regards to the earlier applications of a possible indispensable parties principle, certainly yes, that is the case. But I looked directly at the monetary gold principle itself. It is after all the only case that got the principle named after it, and I looked at the actual decision itself. So I did the court makes no reference to previous decisions. It makes no reference to where it got that principle from. It just says it is embodied in the statute of the court rather than embodied in international law or in previous decisions or whatever else it could have, whatever other wording it could have used. So I hope that answers the question as briefly as I could. Thank you.
Thanks very much again, Leoni. Very, very interesting. So now there is a breakout group. Would this be on this same web room, or do we need a new link?
I think the same link would apply. So you just click on it, and then when you return, you click on the original link so that we return here.
Yeah. Okay. Thanks very much for.
And we'll be back in about 15 minutes.
Yeah.